Welcome, everyone. I am getting our closed captions up and running while you all log in from the waiting room. Okay, the closed caption should be up and running with the red live box. Thank you for joining us after Veterans Day weekend. Welcome back to the third installment of Military Mondays. Today, we're going to be learning about Veterans Records Review with Olivia Cole, who is the Deputy Director of Legal Services at my favorite place, Swords to Plowshares in San Francisco. So thank you for joining us so early today, Olivia. And I did want to remind everyone that the fourth and final installment of Military Mondays will not be next Monday because that's Thanksgiving week. I figured a lot of people would be out of town. So it will be the Monday after Thanksgiving, November 29th. And that one is from 9 a.m. to noon Eastern time. And we'll be learning about all the basics for VA accreditation. So before we hopped on the webinar today, Olivia and I were discussing that this particular presentation may be a review for some of you who are deep in veterans world, but I always find it helpful to listen to new practitioners. Everyone has their own tips and tricks, so I'm really excited to have an expert like Olivia with us here today. So without further ado, I will pass this over to her. Welcome, Olivia.
Thank you, Christy. Thank you so much for having me. And hello, everyone. I'm going to share my slides here. And then we'll get started. So today, as Christy mentioned, I'm going to be talking about record review for VA claims and discharge upgrades specifically. And I am the Deputy Legal Director at Swords to Plowshares. And for those of you who may not be familiar with Swords to Plowshares, we are a veteran service organization in the San Francisco Bay Area. And Swords to Plowshares provides wraparound services to homeless and low-income veterans, including housing assistance, employment and training assistance, and of course, legal services. In the legal services unit at Swords to Plowshares, we specialize in representing veterans specifically in VA claims and discharge upgrades. So that's what we're going to be focusing on for this record review training today. And we also tend to prioritize representation of veterans who have a mental health issue related to either their claim or their discharge upgrade, because we find that in those cases, attorneys can really have a value add. Those cases can be quite difficult to win without advocacy. And so a lot of the examples that I'll be providing today and a lot of the material that we're going to be covering will tend to lean towards cases where mental health is a factor. But the tips and tricks that I'll discuss are useful, I think, in reviewing records for any case that you're working on, regardless of whether mental health comes into play or not. So, oh shoot, there we go. So just a roadmap for today's training before we get into the substance. I'm going to first, for those of you who are new to this practice area, give you a little bit of background information on record review specifically for VA claims and discharge upgrades. So talking a little bit about the legal standards and the types of evidence that are required to succeed in a VA claim or a discharge upgrade, because of course, you know, what the legal standard is and what evidence you need to provide will influence what you're going to be looking for when you do your record review. So I think that's really important background information for those of you who are new to this practice area to have. And I'm going to touch on just a few rules that are specific to both discharge upgrade applications that are based on or in part on mental health, as well as some evidentiary rules that are specific to VA benefits claims for post-traumatic stress disorder, and specifically for those where military sexual trauma is a stressor. And then we're going to turn to talking about the types of records that you're likely to be reviewing in any given case. And so that includes what I've listed here, the official military personnel file. We'll talk more about that, what that entails later. Service treatment records, which are the medical records from someone's time in the military, VA medical records, as well as touching a little bit on civilian records as well. And I'll show you some examples of some redacted records, and we'll talk through what you're looking for there. And then throughout that part of the presentation, I'll be providing some record review tips and tricks for you all that I've learned during the course of working in this area. And then finally, we're going to sum up the day by talking about how you can take what you learn in a record review and summarize it in a useful chronology that you can then look back on throughout your course, the course of the representation of that client. So as I mentioned before, Source to Plowshares focuses on two types of cases for veterans: discharge upgrades, and those are cases that allow a veteran who had a less than honorable discharge to upgrade their discharge status and gain access to VA benefits. We also focus on VA claims, and a big part of that work is VA service-connected disability claims. And those provide a monthly compensation to veterans who have a disability that's related to or was aggravated by their service. So a little bit more about discharge upgrades. When a veteran has a less than honorable discharge, they can apply. Well, what that means, really taking a step back, is that for a lot of them, they're not going to be able to access things like VA healthcare or other benefits and services that would otherwise be available to veterans. And the reason for that is that there are rules that are put in place by the VA that make it so that a veteran with a less than honorable discharge isn't going to be eligible, specifically because of that discharge status, without, in a lot of cases, some advocacy or a discharge upgrade. And so when that happens, that can keep veterans who very much need the healthcare and other services from taking advantage of them. And so one way to avoid that, or to remedy that situation, is to get a discharge upgrade. And a discharge upgrade can come from either the Discharge Review Board or the Board for Correction of Records of the branch that the veteran served in. So there's two boards that any given person could potentially apply to. And which one you're going to apply to, we won't get into. There's statute of limitations and other things that factor in. But what I want to focus on here for purposes of this presentation is what the standards of review are and what the boards are looking for when they're going to decide whether to grant a discharge upgrade or not. And so the discharge review boards have two things that they are looking for. They're looking for propriety and equity in the discharge. And then the boards for correction of records are looking for whether there was an error or an injustice with the discharge. And these are different words for what essentially ends up being applied as the same standard. So the propriety or error standards for each board, that's really focusing on when the military discharged the veteran, did they follow their own rules? Each branch of service has their sort of standard set of regulations that was in place at the time that this veteran served that governed how a discharge should have been carried out. And so both the boards will look for whether those rules were followed or some sort of error and impropriety occurred. And if there was an error and impropriety, they can upgrade a discharge on that basis. And that can make that veteran eligible for services. And then they're also going to be looking for whether there was an inequity or an injustice. And what that boils down to is essentially, considering the context, any mitigating factors. Was the discharge that the veteran received fair? Like, was it fair at the time, or is it fair for the veteran to continue to have a less than honorable discharge and deal with the ramifications of that and be barred from benefits and services, given the context, given the situation. And that's a very sort of overview version of what those standards are. There's a lot more nuance there that we won't get into for the purposes of this presentation, but what is helpful to know is that when you're doing a discharge upgrade case and you're reviewing records, you're looking for evidence of any errors with the discharge or evidence that will show to the board that the discharge that the veteran received was unfair for whatever reason, mitigating circumstances, etc. And then one other thing to highlight that's specific to discharge upgrade applications where mental health is a factor is that relatively recently, the Department of Defense issued guidance to the boards that they are supposed to consider in determining whether to grant a discharge upgrade. And that was through, there's been a couple of these memos, Department of Defense memos, but the one I'm referring to now specifically is the CURTA memo. That's how it's referred to. And the CURTA memo directs the boards to consider 4 questions in determining whether to grant a discharge upgrade. They are supposed to look at whether the veteran had a condition or an experience that could excuse or mitigate their discharge. Did the condition exist or did the experience occur during military service? And does the condition or experience excuse or mitigate the discharge, or does it outweigh the discharge? And so keeping those 4 questions in mind when you're reviewing records for a veteran where mental health is a factor in their discharge upgrade is another, good thing to do as you're going through records. And one other thing I want to note before, moving on to talking a little bit more about VA service connection is that this is true for veterans who have a discharge upgrade where there may be, PTSD or post-traumatic stress disorder as a factor. It's also true if traumatic brain injury is a factor, any other mental health condition, or if the veteran experienced sexual assault or sexual harassment in the service. So what are some key pieces of evidence that you're going to be looking for in a military discharge upgrade case? This slide has a lot of words on it. I'm not going to read all of this to you, but my understanding is that you'll have these slides that you can look back on in the future. So I wanted to be thorough here, but basically you're looking for 4 categories of information. You want to look for any information about misconduct. If a veteran received a less than honorable discharge, it's typically due to some sort of misconduct in their record. And that can include counselings, what are called non-judicial punishments. They could be charged under the Uniform Code of Military Justice, etc. But you're going to want to look for information about what exactly happened during that veteran service that caused the military to give them a less than fully honorable discharge. You also want to look at what type of misconduct it was. So how much misconduct was there, how many instances, and then was it severe, a lot of severe misconduct, one instance of severe misconduct? Was it, a couple of instances of relatively minor misconduct, et cetera? So you want to get a feel for that. And then you'd also like to put together sort of a chronology or figure out what the time period was where the misconduct was occurring. Was it happening throughout the service? Did a couple instances of misconduct happen all close together in time right at the end of the military service? All of that will be relevant. You also want to look not just for sort of negative evidence in the records, but also proof of honorable service. So did the veteran have previous enlistments where they received an honorable discharge? Did they receive any accolades, commendations? And we'll look at a couple examples of what these look like in records later on. You want to look for any evidence of mitigating factors. So was there any hardship? Did the veteran request a change in station? Did they have some family issues, any injuries? And were they experiencing mental health symptoms? And so you're going to be looking for not only things like mental health treatment, but also corroboration that they might have been in a situation that could have caused them to be experiencing some trauma or having mental health symptoms, like were they in a combat zone, what type of job did they have, etc. And then finally, you're going to be looking for their post-service trajectory, what's happened in their life since they got out of the military. And for discharge upgrades specifically, it's helpful to put forward evidence of positive post-service contributions to society. And so what a lot of people think of when they hear that is things like volunteering, working at a church or in a support group. But that can also include things like successfully treating or being involved in substance use services. It can include going back to school, getting custody back of the veterans' children, and a lot of other things. So I always recommend thinking broadly about what could sort of qualify as that post-service positive contribution and putting that evidence forward. And so you can look for that information. You, of course, can ask your client about it, that evidence of that is not going to be, of course, in their military records, since it's things that happened post-service, but there might be mentions of it in VA records or other civilian records. Okay, so that's a bit of background on discharge upgrade, what the standards are, what evidence you might be looking for. Now let's talk a little bit about service connection, and then we'll get into the records. So VA service-connected disability compensation is a benefit for veterans who have a mental or physical health condition that can be linked back to their military service. This is a tax-free benefit, it comes monthly, and the amount that the veteran receives is based on a rating that is tied to the severity of their symptoms. And that rating can be anywhere from 0%, which entitles them to no income, to 100%, which is upwards of $3,000 a month in disability compensation. So this can be a really life-changing benefit. In order to be eligible for service connection, the veteran is going to have to prove three things. First is that they have some sort of current physical or mental health condition that they have symptoms of today. The second is that there is something that happened in service and then during that point in time. And then the third is that there's a connection between those two. And so that third element, the nexus, that has to be provided by a medical professional. But, you know, of course, in your record review, you're going to be looking for evidence to support all three of these elements. And then some secondary considerations you might be looking into are the rating. So, you know, how severe are your client's symptoms? You want to put forward the evidence that you can to get them the rating that they're entitled to. And then another consideration, you might be looking at the effective date of the award. So when did the symptoms begin, and how far back in time are you going to be able to get the veteran benefits? One last thing about service connection that I wanted to mention before we go any further and get into the records is that the VA has some various different rules or relaxed evidentiary standards for different claims, for different conditions, depending on a lot of different circumstances. So I, of course, can't get into all of those today. For example, you know, there's claims for conditions that are related to Agent Orange exposure. Some of those have their own rules and presumptions. There's, you know, other conditions that have presumptions like multiple sclerosis or chronic conditions. Schizophrenia has some presumptions of its own. And so for a lot of different conditions with the VA, you're always going to need to prove those three elements, but to what level you have to prove it and whether a presumption will apply that will make that path forward easier for your client is going to depend on, you know, what the condition is that you're filing for. So, you know, my first recommendation here is always to do a little bit of research about the specific condition that you're filing for service connection for your client, and make sure you're aware of any presumptions or relaxed evidentiary standards that apply to that particular claim or condition. And one I want to focus on specifically today is claims for service connection for post-traumatic stress disorder, where military sexual trauma is the stressor. And there's a couple of reasons I want to highlight this before we move on. One is that I specialize in representing veterans who've experienced military sexual trauma. So this is something that I'm looking for in my practice frequently. And of course, it's familiar to me. But another reason that I mention it is because I believe that the practices that you use when you're looking into a military sexual trauma case and the types of evidence that you're looking for that the VA specifically deems admissible or acceptable in these cases is evidence that it's helpful to look for in any case. And although it might not be the situation that in a claim for depression, for example, the VA will accept different types of evidence that they might accept in a military sexual trauma PTSD claim in order to prove certain elements, it's still helpful evidence to have and provides context in the narrative to the claim that you're filing. So I want to back up a little bit and just explain military sexual trauma for those who are not familiar with the term, and then talk briefly about the special rules that I've mentioned here that apply, and then we'll get into the records. So MST military sexual trauma is unfortunately quite common in the military and includes sexual assault and sexual harassment that occurs to both male and female service members while they were in the military. And unfortunately, although MST is very prevalent, it often is not reported. And there are a variety of reasons for that, including stigma, embarrassment, fear of retaliation, and other reasons. And unfortunately, like I said, this is quite common. And because most survivors do not report, there's not going to be that report in their records that proves that the military sexual trauma that they experienced occurred. And under the current VA rules for successfully claiming post-traumatic stress disorder, the veteran has to show some evidence that a trauma occurred in service, and that's what goes to that sort of in-service element. And so you can imagine in certain circumstances, it might be easier or harder for a veteran to prove that a traumatic event occurred during their service. For veterans who were in combat, the rules are really relaxed. And if the veteran, reports that they were near an IED explosion, for example, or witnessed the death of a fellow service member, then in those cases, as long as there's proof that the veteran served in combat and what the veteran's reporting occurred is consistent with what you would expect to occur in a combat zone, then the veteran's statement alone is going to be sufficient to prove that in-service element for their VA service connection. But in military sexual trauma cases, where the veteran has to put forward evidence that a sexual trauma occurred, if there's no report, there may not be anything directly mentioning the trauma in the veteran's records, and the VA requires them to put forward not just their statement, but also some other version or form of objective corroborating evidence. And so because the VA has recognized that that's hard to do for a lot of claimants, they've relaxed their evidentiary standards and will accept a lot of different forms of evidence to substantiate these claims. So one form of evidence that they'll accept that they don't typically look at or explicitly look at in other cases or other claims is behavior change markers. And essentially what you're looking for in one of these cases is, what was the veteran like before the trauma occurred or before the mental health condition onset, if it's not an MST claim? And what changed, or how did things change? And what's the timeline of that? So essentially, you're trying to establish your client's baseline, and then at whatever point in time, something changes, and then you want to show the VA by pointing to these different markers that something has changed and that trajectory corroborates a trauma or the onset of a mental health condition or whatever other thing it is that you're trying to prove happened. And like I said, these markers in a specific regulation applies only to those post-traumatic stress disorder cases where MST is the stressor. But I do think that this practice of looking through your client's records, taking a step back and trying to understand what your client's baseline was, at what point that changed, and then highlighting examples of or proof that their baseline changed is a helpful practice in any case, particularly MST cases, of course, but also mental health claims for different conditions, and even in cases with somatic conditions where those are being claimed. Okay, so there's a lot of background information, and I know that's probably really broad overview for a lot of you, maybe a review for those who are in this practice area. But for those of you who are new to veterans law, I think it's helpful, like I said, to have that background information going into talking about these records and what you're looking for. So 3 primary types of records that you're going to be looking for or looking at in any given case are the official military personnel file, military service treatment records, and post-service medical records, whether they be through the VA or a civilian provider. These are the sort of primary records in all cases, but they're not exhaustive. So there can be, of course, other records that you're going to want to track down or that could be beneficial to your case. We're just going to discuss these because they're the most likely to come up. The OMPF includes basic information about a veteran's service, their duty stations and assignments, performance evaluations, etc. Military treatment records are the medical records or records of any medical treatment that the veteran received during their service. And post-service medical records, either VA or civilian, are those non-military medical records that the veteran has from engaging in treatment after leaving military service. So let's talk first about the OMPF. That includes a lot of information. So, some OMPFs are relatively short, maybe 100 pages. Some of them are really lengthy, and that depends in part on how long the veteran served. Sometimes I think there are some broad differences in different eras in terms of how much gets included in those. But typically you're going to see the types of information that I've listed here. So you'll see the DD-214, which is, for those who don't know, a document that all veterans receive at discharge that lists a lot of information about their service. And we're going to look at an example in just a moment. There will be a list of duty stations, likely will include the veterans' evaluations, performance evaluations, any letters of commendation or awards that the veteran received, and disciplinary records. So what we're looking at here is a DD-214, and this is a relatively recent era version. DD-214s from way back might look slightly different to this, but they are in general going to contain, for the most part, the same types of information. And a wealth of information here. DD-214 is essentially a snapshot of the veteran's service. So you can see here it'll include things like their rank, their military occupational specialty. You'll see awards, any deployments or other information about specific things that they engaged in during their service, dates of service, overseas deployments and the duration of those. And then down at the bottom is where you find the characterization of the discharge. So that could be honorable, it could be general, other than honorable, bad conduct, or dishonorable discharge, or it might be an uncharacterized discharge. You'll see the reason for separation listed here. It's typically something like misconduct. Sometimes it might say drug abuse or whatever other sort of reason is given for the veteran's discharge. The most common one is simply that the veteran completed their enlisted term of service. But for those veterans with less than honorable discharges, it'll usually denote something about the type of misconduct that led to that less than honorable discharge. And then finally, if the veteran had any periods of absence without leave or incarceration, those will be listed as dates of time lost down here at the bottom. But an important caveat, DD-214s, although they can be a great source of information, are not infallible. They're not always complete. For example, the veteran may have received an award that is not listed on their DD-214. Their dates of service might be inaccurate. I've even seen a typo in a social security number here, which can cause a lot of problems for a veteran, despite in and of itself being a small inaccuracy. So although I will always recommend looking to a DD-214 when you first start reviewing a client's records, just being aware that everything you see isn't necessarily accurate, or that what the information is given on this DD-214 isn't always going to be complete. So here's an example of another important document I'd recommend looking for in any case, and this is a history of assignments. And the reason that I'd recommend looking for this, and what I'm often doing in my cases, is figuring out what the timeline is. And especially when working with veterans who served, maybe 20 or 30 years ago, I found that often my clients, they may not remember the specific date or even the year that something, monumental or important in their case happened to them. So for example, in my work with military sexual trauma survivors, they may not remember exactly when a sexual assault occurred. They might not know what year it was, or what month it was, and certainly not what day it was. And so often if I'm reviewing a record in the absence of any information about the date or time that the assault occurred, that can make it really tough, right? Because you're trying to put this timeline together to show, that baseline and then the trauma and then what changed. And so what I found is that instead I'll ask my clients, maybe they don't remember the date or the year, but they may remember, well, I had just gotten to Germany. Or, they might know that they were just assigned to a different unit. Maybe it was springtime and they were in Kentucky, right? So with a little bit more contextual information, and then juxtaposing that or comparing that to the history of assignments, you can start to tease out, what the timeline is of events that occurred in your client's case. This is just another example of what a history of assignments could look like. They do look slightly different for different branches of service or at different eras, but contain, essentially the same information. All right, so what else are you looking for here? You might be looking for things like this: evidence of positive service contributions, achievements, and awards. And some of those will be really obvious, right? So this Army Achievement Medal, if you're, flipping through a 300-page PDF, you're probably going to notice this, like you'll flag it because it's very clear at the outset, just from the looks of the document, that it's an award. But, a word of caution that not all awards will be so flashy. So for example, you can see on the left here an example of a veteran receiving a Good Conduct Medal. And these, look pretty inconspicuous and shouldn't be overlooked, right? There's a lot of different service members listed, one of which will be your client. And if you're not looking closely, you may miss that what this whole document is about basically is that each of these service members listed here received the Good Conduct Medal for the particular period of time listed. On the right, you'll see a letter of commendation. They may be shorter than this, they may be longer than this, but letters of commendation, again, are not quite as flashy as those Army Achievement Medals look in the record, but can include some really helpful information about your client's positive contributions to service, which will be helpful if, like I said previously, you're working on a case where a discharge upgrade is a factor. All right, so now we're going to take a look at a couple different ways that you can see your client's evaluations in service. So the one on the left is an evaluation report. It's, as you can see, it's for a specific period of time, and there's some detail here, right? So it talks about the veteran specifically, with a description of what they've done well or not so well in some cases. And then you'll see on the right, more of an overview of the client's performance. So this lists, ranks or ratings for the client over the length of their service in a timeline or a chronological fashion. And this also includes, you might notice if you're looking closely, although I know these are small slides and hard to read, that on the enlisted performance record on the right, you can see where the veteran received a couple of non-judicial punishments. So that's basically reprimand for misconduct. And so these two types of evaluations, they serve different purposes, right? And you should be looking for both of them. The one on the left obviously gives you more of that contextual information, the narrative information, sometimes can include things that are relevant for, both a discharge upgrade, of course, in terms of putting forward that the veteran had good performance prior to whatever led to the discharge that was less than honorable, but also for service connection claims. You may find that in these official military personnel files, you're finding descriptions of behaviors that are actually symptomatic of a mental health condition. And if you're not thinking creatively or looking closely at these documents, and you're thinking, well, I'm working on a disability case, so the service medical records are going to be, that's where I'm looking, that's where I'm going to find the information I need. That's not always so. You can find a lot of good information in the OMPF as well. So that's what's helpful, for these detailed reports. But then looking at the enlisted performance record on the right, you can really see the client's trajectory. As I said, I've been, harping on that. It's really important in a lot of cases, particularly mental health cases, to show something about the client's trajectory and how that may have changed. And so looking at it this way, you can see over time, how was their performance doing? Did it start out well and then at some point suffer? Was it kind of up and down throughout their service? What's going on here? What's the record telling you? And I used this one specifically because, when we give this training to the pro bono attorneys that we work with, we highlight this because, I mentioned you can see that the client got a non-judicial punishment early in their service and then had another one about a year later. And so if you're thinking about this without certain information or context in mind, you might think, oh, well, that does not look great, right? They had misconduct sort of throughout their service, 2 NJPs, and then they got discharged. It was sort of spread out in time, not all part of one incident that happened at the end. But in this case, actually, it ended up being the fact that the first non-judicial punishment that the veteran received occurred right after they experienced a military sexual trauma. And then the next one occurred a year later on the anniversary of the trauma. And that's actually quite common in trauma survivors to have symptoms triggered around the time of year that the assault occurred. And so with that context from the client in mind and looking at this trajectory overall, you can start piecing together the timeline for your client and your evidence that you're going to put forward. So starting to get into some of the records that denote or show evidence of misconduct. These two here are counseling records, and counselings are, not severe misconduct. It's not things that rise to the level of a reprimand, like an Article 15, and certainly not that rise to the level of being charged under the Uniform Code of Military Justice and having a court-martial. But they're helpful to look at for the information that they can provide, which is, again, that sort of contextual narrative information. And as I said before, these records can include information relevant to service connection claims, even though, on the surface, at face value, they're talking about misconduct. As I mentioned, a lot of behaviors that are characterized as misconduct in the military are actually symptomatic of a medical condition. So the left gives a really good example of that. In this counseling form, the veteran was counseled basically for having a personal hygiene deficiency, not keeping their locker clean, not keeping themselves sanitary. And, we're basically told, hey, you need to get it together. You need to, get this under control. And so there's nothing here explicitly that talks about depression, but in fact, this client had major depressive disorder. And during their service at this time, they were experiencing their first major depressive episode, which is what was leading them to, not be able to maintain their personal hygiene. The example on the right is for a service member who was diagnosed with a personality disorder during service and was counseled on, changing their behaviors in order to maintain their position within the military were told, if they didn't correct those behaviors, that they were going to be discharged. And so you want to keep an eye out for these types of records, both for discharge upgrade purposes, but also for service connection if you're looking for those clues about a client's mental health condition or their emotional state. So turning now to the discharge paperwork, you're typically going to see in the OMPF either if the veteran had an administrative separation, you'll see the administrative separation paperwork, or if they were court-martialed and went through sort of a trial-like process and were discharged due to the court-martial conviction, then you'll see the court-martial records. And these are a really important place to look, particularly for discharge upgrades, but they're helpful in any case that you may be working on. And the reason for that is that the administrative separation paperwork or the court-martial paperwork is going to basically provide a summary of why the military thought that this person should be discharged and receive the discharge that they received. And you want to keep an eye out specifically for any lists of enclosures that denotes records that the military relied on basically to support their position. And something that I think is really important to flag, especially for those who are new to this practice area, is that not just like the DD-214 is not an infallible document, is not going to always have the complete and accurate information. The official military personnel files are not always going to be complete. And in fact, in my experience, almost never are. And so, but there's not going to be, a sort of highlighted page at the top of the document or circled in red places in the record where things are missing, right? Like you're not going to necessarily know that something isn't there without going back and double checking and being sort of meticulous about this yourself. So whenever I see a list of enclosures, I'm always thinking to myself, do I have all of these documents, right? For this client specifically, the administrative separation paperwork listed 3 statements from supervisors that were relied upon as a reason for this veteran's discharge. And I didn't have those records. I knew I hadn't seen them. I went back and double checked and I couldn't find them. So, we had to go through a process of trying to figure out if we could, ultimately find those records. And I will say that in a lot of cases, if you're specific in what you're looking for and you request it, explicitly, you can find those sort of missing records. But in a lot of cases, unfortunately, records that are missing cannot ultimately be found. But of course, you want to make sure that any records that are available in your case, you've attempted to request and you've done your due diligence in tracking those down. So this is what charge sheets, disposition forms look like if your client has been court-martialed or recommended for court-martial. And for those who might not be familiar, an administrative separation can lead to a general or an other than honorable discharge. It's administrative, it's not punitive. The veteran isn't going through a trial-like process and being convicted, and that's leading to their discharge. It's, kind of a bureaucratic office matter, so to speak. And then if your veteran has been court-martialed, received a punitive discharge like a bad conduct or a dishonorable discharge, that's that trial-like process. They've been charged under the Uniform Code of Military Justice, and they've been convicted with some sort of offense, and that is the reason that they're being discharged and receiving a punitive discharge. And so you're not going to see both the administrative separation paperwork and the court-martial paperwork in the same client's records in most cases, although occasionally you may see that a court-martial proceeding was started, but then the veteran may have accepted a less than honorable OTH discharge through an administrative separation process to avoid the trial by court-martial, kind of analogous to like taking a plea bargain in the civilian context. So that's the one case where you might see some documents related to both, but in most cases it's going to be one or the other that has occurred. If your client was court-martialed, they were charged, there was a court-martial held, then really helpful and important records are going to be the court-martial transcripts, that basically like that court reporter recording of what happened during the court-martial. And I point this out because court-martial transcripts often are not included in the official military personnel file that you might receive from the National Personnel Records Center or from the branch of service. You'll often have to request these separately. And I actually will plug quickly that Swords to Plowshares has a self-help guide on our website. We have many of them, but we have one specifically on requesting military records, including court-martial records, if you'd like more information on how to do that. I would highly recommend it if you know your client's been court-martialed. There's a lot of juicy information there that you'll really want to know, and honestly need to know, particularly, of course, if you're pursuing discharge upgrade, because you'll want to be able to address any negative evidence head on. Okay, so that's the OMPF. Of course, there are going to be many more records that you'll see when you're reviewing an OMPF than I can, show examples of and talk through specifically here. But before we move on to the service treatment records, the major takeaways that I, would recommend that you have when you're thinking about the OMPF is to, double check, make sure you have all the records that are listed, to think creatively about what you're looking for and keep an open mind for what evidence you might find in an OMPF, and how it might be relevant, how you might be able to use that evidence. And then finally, to look at it holistically, try to, find both those narrative contextual bits and pieces of information that help paint the picture and tell the story of what your client experienced in service, but also taking a step back and looking at the big picture timeline of things and the trajectory of the client's service. Okay, so turning to the service treatment records. As I mentioned before, these are the client's medical records. So any medical treatment that the veteran received during service, ideally would be in the service treatment records that you're going to receive. And that typically starts with an entrance exam and ends with an exit exam. But in between those two sort of bookend exams, it'll include chronological records of medical care, pre and post deployment evaluations, immunizations, dental records, which I highlight because they are not to be overlooked, as I'll talk about more in a moment. But let's look here at an enlistment exam. So like I said, this is typically sort of the first in time medical record that your veteran will have when they're enlisting in the military. And I say the first in time because I realize I haven't mentioned this yet, but for those of you who haven't received and started reviewing an OMPF or service treatment records before, you may not know this, but the records, I don't think I've ever received one where the records are actually in chronological order. They'll be in my experience, a completely random order. And it'll be sort of on you as you're going through the records to figure out, like I say, what that timeline is. And I'll talk more at the end of the presentation about how, when you're doing your record review, you can create a document that helps you do that. But, for now, just suffice to say, this is the first medical record in time that your client may have related to their service, but often it's not going to be the first thing in the STRs. And sometimes it's even included in the OMPF rather than the STRs. But typically, you're going to want to find this record and take a look at it. And there's a couple of reasons for that. Obviously, it includes a lot of information, but for service connection claims specifically, the VA will apply what is called the presumption of soundness, which means that if, when a veteran enlisted, no medical conditions were included on this enlistment exam, or any given medical condition was not included on the enlistment exam, then the veteran is going to presume that, or the VA is going to presume that the veteran was of sound mind and body when they enlisted. So, of course, for proving service connection and that a physical health or a mental health condition onset during service, that's helpful, right? Because you can point to this clean enlistment exam and say, hey, when they came in, they didn't have PTSD, that wasn't reported, that wasn't noted, and now they do. So, that goes to support your claim that it onset during service or because of something that happened in service and not because of some sort of pre-service experience. Now we're looking at an exit exam. So you can see it's like the exact same form essentially, but this one is going to be completed as the veteran is being discharged from the service. And, you know, ideally in a perfect world, you're going to have a lot of information here that'll be really helpful to your case. So for example, you know, whereas the entrance exam was clean, the exit exam will say, you know, that the client has been experiencing headaches or nervous troubles or depression, excessive worry, memory problems, you know, whatever it may be, something that'll be helpful for your case. And you can contrast this exam and what was disclosed on it to the enlistment exam. There may also be, you know, some notes explaining what has been checked off. So here in this example, you can see that, you know, the client mentions being hospitalized for a while, had some medical and surgical history, you know, was treated with Valium for frequent headaches, etc. So you might get some more detailed information there, although a lot of times boxes are checked and there's not additional context. However, for a lot of clients, there's not going to be much on this exit exam. And I've anecdotally, you know, talked to my clients about this, and what I've heard is that in a lot of circumstances at this point in the discharge process, veterans are maybe encouraged or even in some cases coerced not to disclose their medical problems at this point for fear that it will delay their ability to be discharged. And at this point, you know, a lot of service members, especially if they've had that experience, may just be ready to get out of the military and they don't want to delay that process. And if they're told that, you know, hey, if you disclose your PTSD, you're going to have to stay in 6 more months and they're going to med board you and you're not going to get out, then they may choose not to disclose it because they don't want that outcome. So there won't always be information here that's going to be helpful to you. If it's here, that's great. But if it's not the end of the world for your claim. There's still a lot of additional evidence you can, you know, potentially find in the records to support your case moving forward. Okay, so this record has 2 purposes. Everything I included here, you know, I did for a reason. And one of the reasons I included this is just to give me the opportunity to say that a lot of the records are going to be handwritten, particularly for older era veterans. And this one, you know, actually the handwriting isn't too bad, but I've seen some that are just truly illegible. And so a couple of like very sort of down and dirty tips and tricks for reviewing records that have handwritten components. I have found that printing out the record can really help highlighting, like specifically printing out and highlighting the word that you're trying to read. And then honestly, if all else fails, like phone a friend. So I, you know, back in the days when we were working in our actual office, very often I would be printing out a record and just carrying it around the office and showing it to various people and saying, what do you think this says? And, you know, if you know, 5 out of 7 of us thought that it said depression, then we would go with that, right? So sometimes that works, but not always. Honestly, sometimes there are going to be records that are just illegible, and unfortunately, that is what it is. But the other reason I included this record is because I wanted to take the opportunity to point out something that comes up a lot in mental health claims, and particularly mental health claims for older era veterans when information about mental health was less common knowledge, and there's still a lot of stigma about mental health, but there was especially a lot more stigma. I think that's something that's been improving over time. So back in the Vietnam and other eras, there was a little bit more of that stigma, and there was just less knowledge, I think, in the general populace about mental health. And so something that I always keep an eye out for, and I would recommend that you keep an eye out for as well, is the somaticization of mental health symptoms. So let me explain what I mean by that. Basically, you're looking for the veteran having described a mental health symptom in a physical somatic way. So here it's a panic attack, but they've described it as shortness of breath and heart palpitations. Here I want to point out if your client was listed as being seen at a mental health clinic, but you don't have records of that mental health treatment, then you're going to want to request those or make a note to yourself to request those. I also want to recommend that you not overlook records that don't necessarily seem relevant at the outset. One of these is a family clinic, one of these is an ER clinic. Both of them include really useful information about mental health treatment or mental health symptoms that these veterans experienced. Also, not to be overlooked, radiology reports and testing. These records look really slim. You don't see a lot of that writing there that shows context, but if you look, you'll see one of these specifically to the left says that the patient was assaulted this morning. In a service connection case for MST, that's really helpful. The other one is a pregnancy test, which you may not know if you didn't look carefully. And then finally, to flag, as I said before, dental records are not to be overlooked, especially if you're working in a mental health case. I think it can be really tempting to you scroll down, you get to the teeth and you're like, all right, I'm done. There's not a lot more to be found here, but you can occasionally find little gems of information in the handwritten notes related to dental treatment. The tech might notice that the client was really anxious, for example, or you might see, oh, they were really doing a great job attending all their appointments until after something happened, and now they're not showing up for any dental treatment. Okay, so quickly to sum up, I want to talk briefly about post-service medical records and then a little bit about a chronology. So post-service records, these are VA ones that we're looking at. They include a lot of helpful stuff. Screens for things like depression or anxiety, which can be helpful even if your client hasn't been formally diagnosed. If they've screened positively, you can put forward that evidence. The VA also screens for military sexual trauma. Of course, civilian providers are likely not to do this, but it's something to look out for if your client has VA records. Then you want to look at the history of present illness, which is called the HPI. This is the veteran's report of what they've been experiencing. It's a little bit more subjective. You'll also see what's called the mental status exam, which is the provider's report of what they're observing about the client. It's a little bit more objective, so keep that in mind. And then of course, you're going to be looking for things like diagnoses. So to wrap up, I just want to talk about, what are you going to do with all this information, right? Like you have the standards in mind, what you're looking for, what types of records to look for in the OMPF, what types of records to look for in the STRs. But like I said, it's not all in order. And how are you going to make sure that the time that you spend doing that, because it usually is a lengthy process, if you're going to do it really well, isn't wasted, and you're not going to have to repeat that work down the line. And so what I recommend is a chronology, a detailed chronology. And this is a sample here, and I can also send out a Word doc of this template that Christy can include with the follow-up materials. But the main tips I want to, impart are to make it actually chronological. So of course you want to go put in here in date order what records you're seeing, cite to the record and where you found it so you can easily find it again. And then really importantly, you want to make sure that what you're including isn't way too much information about each individual record, because if you have a 200-page record and a 70-page chronology, right, the chronology is not saving you that much time. But if you've included enough information to, remind yourself what you found and you've included the citation, you can go back and find that later. And I'd also recommend, backdating things that you find in records. So for example, if your client mentions in a medical record from 2008 that they were raped in 1990, then you want to put a spot in your chronology for both of those things, and you can cite that same record. Finally, I'd recommend including some action items for yourself. So if you saw mental health records mentioned, but you didn't have those records, make a note to request them. And then leave yourself a summary right after you've finished creating this, right after you've reviewed all these records. Just describe sort of your takeaway, reviewing the records, what the records told you about this case, what you learned, what it seems like the story is here. And then you can refer back to that later to refresh your memory if some time lapses between when you do this record review and when you ultimately are picking it back up again for further advocacy. Okay, so I know I ran a little bit through to the end of our time. Christy, I'll leave it up to you if there's time for questions or not.
There's always time for questions. We had a couple come in. So anyone who needs to leave, we will not be offended. But I did just type in the CLE number. If anyone's pressed for time, it's 2108768, N as in Nancy. Again, that's 2108768N. And that will go out tomorrow with the recording and the PowerPoint and the other materials that Olivia has mentioned. I also put the link to the Swords to Plowshares resource page in the chat and the Connecticut Veterans Legal Center page. Those were really helpful to me when I was starting out. And the biggest thing is to not be intimidated by these records. So I hope this training has helped you overcome that fear and that you don't go running in the other direction when you see these records. I think of it like a treasure hunt.
Yes, and it's so interesting. I put on my investigator hat.
Yes, exactly. It's really a treasure hunt, and timelines are absolutely essential. Okay, so first question, do the Curta memo factors go to the propriety or error prong or the equity and justice prong, or are they just considered overall in granting an upgrade?
That's a great question. And honestly, I don't think that the Curta memo is very clear about how they're intended to be applied. And beyond that, are the boards, applying them uniformly in the same way? I would say not so much. In general, when I'm advocating for a discharge upgrade and the Curta factors are part of that, then I'm thinking of them as sort of overall considerations in granting the upgrade. In my experience, it's been a lot more difficult to win a discharge upgrade on the error or impropriety standards because the Department of Defense does use a presumption of regularity for government affairs, meaning that unless you have sort of smoking gun evidence that the military didn't follow their own rules, the Department of Defense isn't going to take the veteran's word for it. They're going to assume that the military did what they were supposed to do. And so it's typically hard to succeed in a discharge upgrade, in my experience, under those standards. And I'm typically focusing more on the the injustice and inequity arguments. But to answer your question, when I'm briefing these, I think of them as sort of overall considerations, and particularly the liberal consideration aspect of that as sort of an overall consideration.
Mm-hmm. And just be creative. The good thing about there being so many gray areas and confusion in this area of law is that you can use that to your advantage and really absolutely. Get creative. Can anything be done when the veteran signed an agreement accepting the discharge classification, but now wants to argue it because it was unfair?
Yes. And in fact, in almost every case that I've had, the veteran has signed some sort of paperwork related to the discharge, that they've been told that they had counsel, etc. Again, if the arguments that you're making are about error or impropriety, that'll make that tougher to win. But if it's specifically, an equity or an injustice argument, then I haven't really seen that factor in negatively for the client.
Any tips on, oops, I just lost it. Where'd it go? Any tips on the best way to obtain military records for a veteran? I know someone who has asked in the past and not received them.
Yes, so again, I'll plug the Swords to Plowshares self-help guide that we have on requesting records, but I will say that, especially if that was within the past 2 years, the National Personnel Records Center, which is where a lot of veterans records are held, has really downshifted their granting of or fulfilling of these requests because of COVID. And other than some limited requests that are being filled for homeless veterans specifically. I'm just the same as you and that other person having a lot of difficulty getting these records right now. And unfortunately, I don't have an answer or a go around for the COVID closures.
I highly recommend VBMS electronic access if you're going to be taking these cases. It's a royal pain to get through the process. It takes forever. You have to follow up a million times. They deleted my account earlier this year, so I had to go back and get a new card, but it's worth it is the lesson there. It's totally worth all the hardship because I really can't imagine just waiting forever on these records. It's amazing.
I completely agree. And VBMS will most likely have your client's military personnel file in the service treatment records if they've ever filed a VA claim before. Unfortunately, if they've never filed, then you may not be able to find anything in there either.
I have a feeling James Heaton will address this in the November 29th session on VA accreditation. He has a hilarious, very humorous guide to getting VBMS access. So I'll make sure he shares that during that training.
Yes, and someone just mentioned in the chat, which I think is a great point, and I'll echo it here, is FOIA requests can also be used to get records if you're having trouble.
Great. Yeah, and the thing I love about VBMS is you see like the memos and the notes between the VA employees and things you never would have known, like billing issues, just everything. Someone had, Laura in the Q&A box has a great idea for a future training, asking about what about if an upgrade is denied, which happens a lot. How do you appeal that? Oh boy. I will definitely put that on my training wish list for next year, Laura. Great idea. Last question. Are these issues more common with enlisted people as opposed to veteran officers? Does an active military person have a right to review their record before a discharge?
So I will say that I see these issues both with enlisted folks as well as officers. In my experience, the discharge review boards are a little bit tougher on officers who are requesting a discharge upgrade. I don't know if that has to do with some stereotypes about officers as opposed to enlisted folks, or wanting, the boards thinking that those officers should have more, more responsibility for their actions or whatever it may be. But I have had the experience that the battle is a little bit tougher uphill for officers than it is for those who are enlisted. In terms of your other question about active military members having a right to review their record before their discharge, that's honestly a question I don't know the answer to. I will say anecdotally for my clients, I've never heard of any of them being given that option. Most of the clients that I work with either never saw their records until I started working with them, or if they did have a copy of their records, they described kind of having to fight tooth and nail to have gotten it from the military before they were discharged or at the time of their discharge. So my pessimistic gut kind of says I think not, but again, I don't have detailed information about that, unfortunately.
It seems to me like they have to know to ask for it, and they may not be able to review it until they're out the door, but if they know to ask for it before they get the boot, oh my goodness, it's so helpful to have that to start with while you're requesting other records. Definitely. Well, thank you so much for all this good information, Olivia. I really appreciate you joining us so early in the morning, your time.
No problem.
To share your knowledge with us. All right. I hope everyone has a good afternoon. Take care.
Thank you. Bye-bye.
Bye-bye.